So, I just got off the phone with Kirk Pendergrass from E-Clause, Kirk's Law Corner Monday night. And on Friday, we're going to be doing a completely free Zoom. This predates the class that I have coming up on Saturday, a completely free Zoom for people to gravitate towards the realization of us being invaded right now as a nation. It's incumbent upon us to stand up and do the right thing, acting in good faith. Kirk Pendergrass desires to follow the due process of law and petition the government to declare a state of emergency as well as declare war because of the foreign invasion from military-aged men being admitted into this country by the Biden administration. And this is clearly a dereliction of duty on the part of the Biden administration. These people are treasonous rat bastards, and something needs to be done. And when the government won't do its job, it's time for the American people to stand up, sound off like they got a fucking pair. So on Friday, Kirk and myself will be holding a Zoom to help you guys out. He's put a petition together that we can all sign to shut this shit show down. It's time for the American people to stand up and sound off like a got a pair. If you don't have guns and bullets, I suggest you find friends that do, or you go and acquire some yourself, because what is transpiring is the same thing that happened in Europe not too long ago. It happened in France, it happened in Germany, it happened in Istanbul, where they allow migrants to come into a foreign nation, and they have different customs, of course, and because of the different customs, it creates complete and utter chaos. There is a process for being admitted into this country, and that process should be followed. Okay, so they're violating the law. They're derelict in their duty. They're in breach of their oath of office. They're in breach of their fiduciary duty, and it's time we, the people, stand up and sound off like we've got a fucking pair. All right? And Kirk's ideology is to do this in a lawful manner until push comes to shove, which I completely agree with him. So Friday, Kirk and myself will be doing a free Zoom call. I will post all the information later on my Facebook wall here as well as YouTube for everybody to join. He's got a petition that he wants everybody to read and sign if they feel comfortable signing it. Again, he's following the law, due process of law. He's expressing his grievance with the legislator, with Congress, and saying, hey, we need something done, and we need something done now. Not tomorrow, not a week from now, not a fucking year from now. We need it done today. And so we hope that you guys will join us for that. So, brings me to my next point of business and order today. And I guess I'm going to go ahead and move the camera around so you guys can actually see what I'm reading. And above this video, I will post the link, and below, I'm going to show you how a group of American men and women alike single-handedly destroyed the American Bar Association. In fact, the guy who created this document, when they went to enforce it in court, they put him under witness protection program. Not only did he go into a witness protection program, but the IRS also put a protection order on him as well to save this man's life from what he had exposed. Okay, and there were a number of people that were involved, and so when I contacted him, I got a hold of one old chap by the name of Steve, who was part of this, and I said, what kind of trouble were you guys in when you started down this path? And they said, the honest to God's truth, nobody that was part of this was in trouble at all. We just saw a nation in distress, and we took immediate action. And I carried on a conversation with this man. He's 75 years old, very brilliant, very intelligent man. I graciously told him thank you for his time and his care and consideration and explaining to me exactly why they were doing what they were doing. So with that said, this document's about 44 pages. We're going to try and get through it all in one shot. I'm going to reverse the camera here so you guys can see it on the screen as well. And I'm also going to post a link for it. This is how you destroy the American Bar Association. By the way, ladies and gentlemen, all Bar Association members can be destroyed with this document. So let me reverse the camera right quick and make sure you guys can see it. And let's see, reverse camera. All right. And lower the camera. You guys got that in your view? Give me a thumbs up if you can see that. All right, here we go. American Bar Association and International Bar Association Affidavit of Obligation International Commercial Lien. This is a verified plain statement of fact. dated October 15th, 2015, ladies and gentlemen. I'll blow this up a little more so you guys can really see it. All right. Maxims. All men and women know that the foundation of law and commerce exist in the telling of the truth and nothing but the truth. 2. Truth as a valid statement of reality is sovereign in commerce. 3. An unrebutted affidavit stands as truth in commerce. 4. An unrebutted affidavit is acted upon as the judgment in commerce. 5. Guaranteed, all men shall have a remedy by the due course of law. If a remedy does not exist, or if the remedy has been subverted, then one may create a remedy for themselves and endow it with credibility by expressing it in their affidavit. So we do testimonies in the form of an affidavit, all right? And we sign them under jurat. 6, ignorance of the law might be an excuse, but it is not a valid reason for the commission of a crime when the law is easily and readily available to anyone making a reasonable effort to study the law. 7, all corporate government is based upon commercial affidavits, commercial contracts, commercial liens, and commercial distress. Hence, government cannot exercise the power to expunge commercial process. 8, the legitimate political power of a corporate entity is absolutely dependent upon its possession of commercial bonds against public hazard. 9, no bond means no responsibility, means no power of official signature, means no real corporate political power, and means no privilege to operate statutes as the corporate vehicle. 10, the corporate legal power is secondary to commercial guarantors. Case law is not a responsible substitute for a bond. 11, municipal corporations, which include cities, counties, states, and national government, have no commercial reality without bonding of the entity, its vehicle, statutes, and its effects, the execution of its rulings. 12, in commerce, it is a felony for the officer, public office, to not receive and report a claim to its bonding company, and it is a felony for the agent of a bonding company to not pay the claim. 13, if a bonding company does not get a malfeasant public official prosecuted for criminal malpractice within 60 days, then it must pay the full face value of a defaulted lien process at 90 days. 14, except for a jury, it is also a fatal offense for any person, even a judge, to impair or to expunge without the counter affidavit any affidavit or any commercial process based upon an affidavit. 15, judicial non-jury commercial judgments and orders originated from a limited liability entity called a municipal corporation, hence must be reinforced by a commercial affidavit and a commercial liability bond. 16, a foreclosure by a summary judgment non-jury without a commercial bond is a violation of commercial law. 17, governments cannot make unbonded rulings or statutes which control commerce, free enterprise, citizens, or sole proprietorships without suspending commerce by a general declaration of martial law. 18, it is tax fraud to use courts to settle a disputed controversy which could be settled peacefully outside or without the court. 19, an official, officer of the court, policeman, etc., must demonstrate that she is individually bonded in order to use a summary process. 20, an official who impairs, debauches, voids, or abridges an obligation of contract or the effect of a commercial lien without proper cause becomes a lien debtor, and her property becomes forfeited as the pledge to secure the lien. Pound breach of impound, and rescue is a felony. 21, it is against the law for a judge to summarily remove, dismiss, dissolve, or diminish a commercial lien. Only the lien claimant or a jury can dissolve a commercial lien. 22,
Notice to agent is notice to principal. Notice to principal is notice to agent. 23. Public hazard bonding of corporate agent. All officials are required by federal, state, and municipal law to provide the name, address, and telephone number of their public hazard and malpractice bonding company, the policy number of the bond, and if required, a copy of the policy describing the bonding coverage of their specific job performance. Failure to provide this information constitutes corporate and limited liability insurance fraud, Title 15 U.S.C., and is prima facie evidence of and grounds to impose a lien upon the official personally to secure their public oaths and service of office. 24. This international commercial obligation lien is in part supported and prefaced on UCC 9102 agricultural liens. UCC 9607 through 610 secured parties' right to take possession after default with all rights reserved. Parties lien claimants: Stephen Dwayne Curry. This is the man that is now under witness federal protection for what he has done here, ladies and gentlemen, so it might behoove you to pay attention. As a witness, a crime victim, an injured individual, living being, representing all listed, unlisted, unknown, multiple crime victims, injured parties, individuals, living beings, and inhabitants in the territory known as Colorado, America, and elsewhere on all tribal lands. 2050 Dave Wood Road, Montrose, Colorado, 81401. The phone number is 970-249-8879. I called that number. That number is no longer in service. Obviously, he is under witness protection. How did I get that information? Well, you see, all of these people I contacted until I got a hold of the other Steven right here. All right? Please don't call him and bother him. I've already called and talked to him. He's a peaceful man. I'm sure he just wants to enjoy his life. But nevertheless, if you feel inclined, be my guest, call. Be polite and respectful. All right, so these are all the names and numbers of the people that were involved in this. And as I talked to Stefan, I called him Steven earlier, he purported that nobody on this list was currently in trouble when they decided to do this. All right? So, let's get to the meat and potatoes, shall we? So these are lien claimants. All right? Right here, lien claimants. Okay? And what's beautiful about this is he left it open-ended so you can sign it too. You could submit it as well. And here's all 36 of them, I believe. 37, 38, 39, 40. These are all lien claimants that are involved. Here's where he leaves it open-ended for you to be a lien claimant as well. Add your name. Add your information. All right? Lien debtors. Okay? The American Bar Association, a corporation, et al. All right? The International Bar Association, a corporation, et al. He got them all, ladies and gentlemen. Executive Office for United States Attorneys. He got them as well. Department of Justice. Nailed them. Individual executives, officers, directors, Board of Governors, commissions on governance, committee members as of October 6, 2015, including but not limited to Department of Justice, the American Bar Association, Patricia Lee Rufo. These are all the people that he put on notice that he's liened. He's now liened these people. And you can join in. And you can add. You can add to this list. Commissions on governance. All these people are involved in this. This is why this man was whisked away to witness protection. Okay? And here's where you can add additional lien debtors. Okay? If you're asking for what, you need to go back and rewatch the beginning of this video. All right? This is a lien against the American Bar Association, the DOJ, the United States government. All right? And he executed a private administrative process and he left it open-ended so you could join it too. All right? This means that if they're going to do business with you, they have to settle up with you first. They have to pay you first. They can't do business with you anymore. They're barred from it. They have a lien in place. Allegation. Now you're going to get to know for what. The allegations, the American Bar Association, the International Bar Association, and the Department of Justice are commercial derivations and subsidiaries of the Crown Templar or Temple Crown, whose corporate headquarters is located in the city of London, England. He gave them an option. Is this correct? Yes or no? If no, please explain. They failed to answer. The juxtaposition is they agree if they fail to answer. Okay? In 2007, William C. Hubbard, Esquire, received the American Inns of Court Professionalism Award for the Fourth Circuit. In 2015, he was called to the bench as an honorary bencher of the Middle Temple in London. Is this correct? Yes or no? If no, please explain. He's giving them an opportunity to explain their juxtaposition. If they fail to respond, the answer is yes. They agree. The American Bar Association, keep in mind this guy did a heavy amount of research before he put this together, ladies and gentlemen. This document had the United States government put this man in witness protection. The IRS came in and put him in witness protection as well because he was showing how the American Bar Association and the International Bar Association is stealing from the United States Treasury, effectively stealing from we the people. The American Bar Association was founded on August 21st, 1878 in Saratoga Springs, New York, by 100 lawyers from 21 states. The International Bar Association, established in 1947, now has over 55,000 individuals and 195 bar associations and law societies, and its organizations continue to grow. Is this correct? Yes or no? He's showing the infiltration of our nation, of our country, by lying, looting, pandering, piece of shit lawyers who turn property from one and grant to another, themselves typically. Okay? Yes or no? If no, please explain. Remember, all of this went unrebutted. So they agree with what he's stating. The first president of the American Bar Association was its inceptor, creator, and implementer, James O. Broadhead. Representatives of 34 national bar associations gathered in New York, on 17th February 1947 to create the International Bar Association. Was this not an act of sedition, treason, and piracy on land pursuant to Title 18 U.S. Code 1651 through 1661? Yes or no? If no, please explain. International members. Now keep in mind, all of these lien debtors, this information got sent to. All of these people. None of them responded, and they all had a duty to respond. Okay, silence can only be equated to fraud when there is a duty to respond. Okay? So all of these people failed to respond to this, ladies and gentlemen. And I got this knowledge, acquired knowledge, from the gentleman who participated in it and had firsthand perfected knowledge of the facts. And he told me they sent this to everybody, registered mail. They failed to respond. They acquiesced by tacit agreement. They then purported to the correct channels of what they had done, and they filed a lien against these organizations. They are not allowed to even think about them, utter their name, without first paying the debt due and owing. All right. 5. Initial membership was limited to bar associations and law society, but in 1970, the International Bar Association membership was open to individual lawyers, member of the legal professions, including attorneys, solicitors, barristers, advocates, members of the judiciary, in-house lawyers, government lawyers, academics, and law students comprise the membership of the International Bar Association. Is this historical notation correct? Yes or no? If no, please explain. They failed to explain. They acquiesced by tacit agreement that it is correct. James O. Broadhead violated the original and organic Article 8, Article 8 Amendment of the Constitution of the pre-1871 continental United States of America when in 1878 he was chosen president of the American Bar Association, which met at Saratoga, New York in 1882. He was elected as the state representative to the 48th Congress as a Democrat, and in 1885 was appointed by the government as special agent to make preliminary search of the record of the French archives in the matter of the French spoliation claims. Making his report in October 1885, he was U.S. Minister to Switzerland 1893 through 97. Do you agree James Broadhead committed treason against the continental United States government in forming the American Bar Association and becoming the first president? Yes or no? If no, please explain. James O. Broadhead's election and appointment were direct abrogations and usurpation of the 1803 Supreme Court ruling over Marbury versus Madison, wherein John Marshall rendered a majority decision restricting barristers and esquires and other holders of titles of nobility from holding government or public office, and declared that prescribing, giving, or taking such oaths of office to these offices was a solemn mockery against the U.S. Constitution, against its people, and was equally a crime. If this is correct assessment of the foundation and legacy of James O. Broadhead, it stands then that the entire concept, structural design, and the implementation of all contracts, i.e. electoral college, lifetime judicial appointments, copyrighted revenue-bearing statutes, codes, rules, ordinances, etc. created by the ABA are fraudulent, malicious, egregious, and corrupt to the ABA, the American Bar Association's core? Yes or no? If no, please explain. Mr. Broadhead's coalition of 100 foreign agents, attorneys, who in concert, collusion, and conspiracy created with the encouragement, support, and aid and embedding of the Federal Reserve debt banking system, the American Bar Association, in their efforts to federalize, democratize, incorporatize, defraud, and to silently overthrow the righteous and genuine constitutional government of the United States, and to subvert, usurp, and to destroy the unalienable and natural rights of the people and tribal families who reside and inhabit the land established by our nation's founding fathers. Would you agree with this assessment? Yes or no? If no, please explain. Number 9. Is it not true, then, that fraud vitiates all contracts, and that all commercial contracts, including but not limited to all unlawful sentences and incarcerations of political prisoners, i.e. imprisoned IRS lien debtors, non-commercial offenders, wherein such commercial contracts were all conceived in fraud and lacking any moral and ethical character, are in direct conflict with natural law and commercial law, and thus every American Bar Association contract since 1882, whether verbal or written, including but not limited to all judicial oaths of office falsely sworn to and fraudulently securitized, monetized, and commercialized, are null and void ab initio. Yes or no? If no, please explain. 10. Our country's founding fathers established our original and organic constitution under the land jurisdiction and not the jurisdiction of the sea or Holy See, with various embargoes against acts of piracy, press ganging, personage, slavery, barratry, and other notorious and potentially injurious foreign intrusions, including the Titles of Nobility Act, the Eighth Amendment, Bills of Attainder, which I believe that's supposed to actually be the Article 1, Section 9, Article 1, Section 10 of the United States Constitution, and other notable and honorable acts and codification of law that were to ensure the health, safety, and welfare of our government, our lands, and our people. Is this historically correct? Yes or no? If no, please explain. 11. If your answer to question 10 is yes, then under the law, form, or forms, was the American Bar Association, the International Bar Association, and their minions able to subvert and usurp the land jurisdiction with the mere presumption of the jurisdiction of the sea? Please select one or more law forms used. A. Admiralty law. B. Maritime law. C. International law. D. Commercial law. E. Uniform Commercial Code. Roman Curia law. 12. The National Lawyers Guild was established in 1937 and, according to historic records, has its origins in the Communist Party. The American Bar Association was in protest of its establishment due to a belief that the NLG was a militant segment of the bar in comparison to the criminal, unethical, and immoral conduct and activities of the members and individuals of the American Bar Association. The members and individuals of the NLG, even if they are referred to as communists, are truly Satanists. As the NLG genuinely and honestly works for the people and not for the corporation, the American Bar Association, so the NLG is National League of Nations, I believe, or nation. I'll have to get back to you on the NLG. I'll look it up. I don't want to misquote it. As the American Bar Association does, is this an accurate description and comparison of the ABA, the American Bar Association, and the NLG? Yes or no? Whoops, shit. During the McCarthy era, the NLG was accused by Attorney General Herbert Brownell Jr., as well as the House Un-American Activities Committee, of being a communist front organization. Federal Bureau of Investigation Director J. Edgar Hoover repeatedly tried to get a successive attorneys general to declare the NLG a subversive organization, but without success. If the American Bar Association was so opposed to the NLG as alleged, why did the American Bar Association's own Attorney General block the FBI's, Brownell's, the House Un-American Activities Committee from prosecuting the NLG when the American Bar Association claimed the NLG is quite simply a militant segment of the bar, American Bar Association? Was this protest by members and individuals of the American Bar Association simply a ruse or a red flag operation to cloak the true intent and nature of the American Bar Association and banking elitist they represent? Please be specific in your answer. 14. The 1944 HUAC history asserted that the NLG was merely a streamlined edition of the International Judicial Organization, a communist party mass organization established in 1931. Is the American Bar Association and the International Bar Association not also corporate member associates of the International Judicial Organization? Yes or no? If no, please explain. The enactment of the 1948 Administrative Procedures Act following the American Bar Association's 1947 Bar Treaty created a multitude of quasi-government corporate agencies. Both efforts and acts further subverted all legitimate de jure government agencies to bring them under the American Bar Association's corporate judicial control and administration, thus destroying the genuine and lawful executive and legislative branch of the people's government. Yes or no? If no, please explain the intent of these two efforts. 16. It is a well-documented fact that the American Bar Association and the International Bar Association are quite simply political organizations with distinct corporate connections to all nations and state bar associations, inns of courts, and the districts and middle inns made up of adjoining state bar associations, and that in order to serve at the bench, all judges from the municipal judge to the justices of the U.S. Supreme Court, according to the Federal Civil Procedures Act, must be members of the bar. Does this districting and the judicial mandating for the seating of judges, justices, and magistrates not violate every nation's states' general laws and rights, abridge individual voter and election rights, abrogate both state and federal constitutions, and completely nullifies the American Bar Association's and the International Bar Association's very own articles of incorporation, policies and procedures, bylaws, and their own professional rules of conduct? Yes or no? 17. Both the American Bar Association and the International Bar Association market their wares and practices as voluntary, yet in actual practice and execution, the American Bar Association and International Bar Association, by all lawful and legal definitions, practice what can only be defined as a monopoly over the entire international and United States justice system, and the American Bar Association dominates the genuine two branches of continental government of the United States. are the requirements set forth in the FCPA then prima facie evidence of this criminal monopolizing of the justice system? And does it not, in fact, encourage and promote the destabilization of the world's governments through judicial and military occupation, political lobbying, social and economic manipulation, and inciting civil protest and unrest? Yes or no? If no, please explain in details. Again, E-Clause went after the American Bar Association as well, and prove that you don't have to have a license to practice law, and that you can go in and represent people and be counsel for people, because a monopoly in this country is illegal. Okay? It's illegal, ladies and gentlemen. So anyway, I know I said we were going to try and do this in one foul swoop. We're 19 pages in. We're going to get to page 20, and then I'll take a break, and we'll come back with the rest of it. So, yes or no? If no, please explain. 18, despite the fact that monopolies and other antitrust RICO activities are both unlawful and illegal on the land, the ABA, the American Bar Association, and the International Bar Association knowingly and willingly operate in ultra-virus and with total disregard and disdain of human rights guaranteed by the Universal Declaration of Human Rights. Okay, now we're talking about law of nations, international law, and the numerous safeguards built into our state and federal constitutions. These safeguards are built into any number of our maxims of law and are constitutionally derived laws, including 15 U.S.C. 1 and 2. Interference with trade and commerce, Title 15, subsection 1, subpart 1. Interference with trade and commerce comes at a penalty of $100 million by the corporation that enacts it, and $1 million by the individual who supports it, upholds it, and tries to enforce it. And Title 15 U.S.C. 2. Which state very clearly and unambiguously the penalties for operating in such a manner. Title 15, U.S. Code, subsection 1, trust, etc., in restraint of trade, illegal penalty. Every contract combination in the form of trust or otherwise being the key, or conspiracy in restraint of trade or commerce among the several states or with foreign nations is declared to be illegal. Every person who shall make any contract or engage in any combination or conspiracy hereby declared to be illegal shall be deemed guilty of a felony, and on conviction thereof shall be punished by a fine not exceeding $100 million if a corporation, or if any other person $1 million, or by imprisonment not exceeding 10 years, or by both said punishments in the discretion of this court. Title 15 U.S. Code, subsection 2, monopolizing trade, a felony, penalty which states every person who shall monopolize or attempt to monopolize or combine or conspire with any other person or persons to monopolize any part of the trade or commerce among the several states or with foreign nations shall be deemed guilty of a felony, and on conviction thereof shall be punished by fine not exceeding $100 million if a corporation, or if any other person $1 million, or by imprisonment not exceeding 10 years, or both said punishments in the discretion of this court. Again, this is why Standard Oil was broken apart, ladies and gentlemen, because they had monopolized the industry. So the government came in and said, either you allow us to monitor you and take part in this so you're not a monopolized industry and regulate you, or you have to break it up. Okay, by doing that, they actually did Standard Oil a huge favor. They became wealthier than they could ever imagine when they started to sell off their company. Anyway, long story short, the American Bar Association has monopolized the justice system, and it doesn't stand for justice. It stands for just us, meaning if you're part of their crew, it's kind of like George Carlin said, it's a big club, and you ain't in it. All right? 19. Used in concert and conjunction with this commercial obligation lien, Title 15 U.S.C. 1 and 2, and the invocation of our crimes victims' rights, as defined and described under Title 18 U.S.C. subsection 3771, the American Bar Association, the International Bar Association, and the DOJ, Department of Justice, by the preponderance of well-documented evidence and by the sheer weight of notable and probable cause already posted in both the private and public records, the individual members of the American Bar Association, the International Bar Association, and the Department of Justice, acting in their corporate capacities, are found to be guilty on both counts and are guilty of all crimes described under the Piracy Code of Title 18 USC subsection 1651 through 1661, 1661 being piracy on the land, and under Title 42 USC 14141, causes of action. So when we come back, I told you we'd get to 20. When we come back, we'll be finishing up. Let me finish this up. Causes of action. Would you not agree that the American Bar Association and the Department of Justice enjoys rights, privileges, liberties, freedoms, and pursuits that are not extended to or enjoyed by non-union members? Yes or no? If no, please explain why your laws are not shared by all and why these laws do not apply equally to the American Bar Association, the International Bar Association, or the Department of Justice, executives, directors, officers, members, employees, or their corporate contractors. Very good questions, ladies and gentlemen. When we come back, we'll be coming back with number 20.